Hello and welcome to this special edition of Financial Detox. I'm Jason Labrum, your host, with Alex Klingensmith, co-host, the greatest co-host in the world. And we have a very special guest today who I'm so excited to bring on, Mr. Brian Raftery. Brian is a partner at the law firm Dentons. He's also the chairman of the Trust and Estates Department. Brian is a guy who can and does regularly help people with complex estate planning needs. And we are finding that this is becoming a bigger and bigger issue, especially now as we're getting closer to that 2025 sunset. So lots of really cool things going to happen today on Financial Detox. If estate planning is on your mind, trust, wills, probate, discounted properties to LLCs, limited partnerships, SLATs, spousal lifetime access trust. Wow, it is all there. We are going to have a really great show. Alex, what do you think? This is fun to have Brian on, huh?
I think it's awesome. And poor Brian, we didn't give him a whole lot of pretext. I think I sent an email 30 minutes before the show with a little bit of like how the show works and how we do this. Like, we're a wealth management firm, right? We're an RIA, independent wealth management firm. And the show is meant to be a consumer advocacy brand, right? So trying to simplify things that are ordinarily very complicated and people try to do themselves sometimes and maybe shouldn't. So this is going to be a fun one because estate planning even is something that we don't even necessarily do the legal work here at IDA, but we bring in great people like Brian to do it for our clients and us, right?
That's perfect. And Brian, welcome to the show. So glad to have you.
It's a pleasure being here. Thank you very much, Jason and Alex, for having me on. And with regard to the 30-minute lead time, hey, that's much more time than I get for most potential new clients. So
awesome.
And I appreciate the summary of what we might actually be discussing today.
That's great. Well,
sweet.
I know I've had Brian on several calls with clients, and he's able to handle that no problem. And he is personable and can make explaining very complex estate planning strategies quite simple and easy to understand. Brian, you're going to probably do a lot of talking here, which will be a big change for a podcast. And any of our listeners at Financial Detox will be pleasantly surprised that I'm not talking as much as normal. With that, why don't we have you just give us an intro and an overlay of what's going on, maybe even as simple as what is estate planning? Because I find that we in the industry tend to gloss over what these big, hairy topics mean. And so maybe a quick definition of what you see as estate planning. And then what are the areas for, residents of California and maybe even around the country, things that you're seeing the mistakes and what we need to talk about today.
Yeah, much like with planning in other areas like financial planning, it's looking towards the future and seeing what can you do now where rational decisions can be made, where benefits can be put in place now that will help you and your family down the road. Because the opposite of planning in my area, and that's the area of trust and estates law, is reaction. Whenever there has to be a reaction because something has already happened, then you're limited with regard to what your responses will be. You're limited with regard to what your options would be. You're not making the best decisions if, heaven forbid, your mother or father or grandparent had just passed. Planning ahead is much better than reacting subsequent to certain things that are very unfortunate actually happening. And with regard to my area of law, we are talking about very sensitive topics. We are talking about, in essence, someone passing away, grandparent, parent, yourself. But it's one of those things that I say to clients, if they have no documents in place and we begin the discussion, some of them feel guilty that they haven't done anything and they might have minor children. I say, hey, look, there's an old proverb that says the best time to have planted a tree was 20 years ago. The second best time is today. So don't feel so bad. We're talking about it. We're engaging and we're planning ahead. And that's the thing to do. I also say to clients who may not have estate planning documents in place that, hey, you still have an estate plan. The estate plan is the plan that the government is going to give to you because you didn't make your own decisions when you otherwise could have. For example, we've all heard in the news with regard to conservatorships, with regard to having certain celebrities having guardians or conservators appointed by the courts for them. An alternative would have been if an individual had a power of attorney. A power of attorney is a document in which you designate someone to handle your finances for you in the event that you're ill or incapacitated and can't do so for yourself. If you don't have a power of attorney, you haven't legally allowed someone to make these decisions for you if you're not in good stead or you become ill or you're in a car accident or what have you. So guess what the fallback is? The courts. The government starts making those decisions for you. As you can imagine, people pass away without wills and revocable trusts each year. Guess who makes the decision as to where your assets go if you haven't made those decisions yourself? In the worst case scenario, I'll just end this particular line on, heaven forbid both parents of a minor child were to pass away. If you haven't designated the guardians of that minor child, then guess who gets to choose who the guardian is? It's not, the godparent that many people thought from decades ago and generations ago. The government, the courts get to choose who the guardian of the minor child is. That may have been someone you would have chosen, and may have been someone who's different. So that's why we call it planning instead of reacting.
Yeah, that's scary. What would you say the percentage of people, the mass affluent, right? We call mass affluent up to maybe $2 million investable assets, high net worth from 2 to 5, 2 to 10, ultra high net worth 10 plus. But what percentage of people don't have a trust right now? Because it's more than than you would think, I believe. But do you know what that percentage is?
I don't know the exact percentage, but from anecdotal evidence and the clients that I have and what have you, with regard to a revocable living trust as an example, which helps to avoid the probate process, which in California can be quite onerous and time consuming and expensive. The vast majority of the clients who come to me may have a will that they did 5 years ago when their child was born because their parents said, you better have a will naming a guardian. But the will is insufficient because their wealth has grown, maybe they have additional children, but they don't have the revocable living trust that will help them avoid California probate. And I would say in the cases that I've experienced, it's about 90% of the time where they don't have that type of revocable trust arrangement. And in California's a community property state where we have 7 offices from San Diego in the south up to San Francisco in the north. But the idea is to ensure that under your community property rules, states like California, Arizona, Texas, New Mexico, that you're appropriately covered with regard to your revocable living trust arrangement. And I would say about 90% of the clients who come in looking to begin the estate planning process or looking to enhance what they have don't have it properly in place, unfortunately. But the good thing is that that's what we're working on, and that's what we do.
Yeah. And the summary here is on that part, which is pretty straightforward. In California, if you have more than, I believe it's now 185,000, is that the right number, Brian?
With regard to
total assets that would force you into probate, if you have over a
and those numbers do change. So even if you have under that, to make the process more efficient, so you don't have to go to the courts at all.
Yeah.
And say, hey, look, I have a relatively speaking small probate proceeding that can be an easier proceeding. You'd rather just stay out of the mix altogether.
Right. Exactly.
You're going to take some less pain, or you could have avoided it, or you're going to try to avoid it altogether.
Very good. And this is, we're talking about a revocable living trust that is going to cost you somewhere between probably $3,000 and $6,000 to set up. It's a one-time expense that then allows you to have not only the wills and the healthcare directives and guardian of your children, but also tells the estate and the government where you wanted your assets to go. So you avoid this lengthy and annoying probate process, which, isn't a problem until it is a problem. So really simple stuff right there. From a high level view is just to get a revocable living trust in place.
Correct. And also transfer assets that you may have in your individual names into the revocable living trust. There are other sets of situations where, for example, in California, where you'll have a joint revocable trust with 2 spouses, where clients are so happy that they have this trust in place. And I'll look at it and say, you know what, this trust that you did, let's say 3, 4, 5 years ago, it looks pretty good. Some enhancements we might want to make, and that's why it's amendable. You can amend a revocable, a joint revocable living trust. But it's like, so what assets does this trust own? What assets have been entitled from the married couple into the trust?
Yeah.
Oh, no, we don't have any, but we have the trust. Well, that's swell, but it's kind of like owning the most beautiful car in the neighborhood, and there's no gas in the tank. It's not an electric car. Like, you can't go anywhere with it. Like, you can't do anything with it because it's not ready to go. A revocable living trust, once it's completed, the idea is if you have a bank account in your personal name, it gets retitled with the name of the revocable living trust. What most people don't realize is that the revocable living trust, it can look beautiful, but if assets are entitled into it, personal homes, your bank accounts, your brokerage accounts, other assets that you may own, if you own a boat, if you own real estate, if you own LLC interests, then in the event, heaven forbid, of your passing, those assets are outside of the revocable living trust. Now, typically there's a catch-all will that will say, hey, look, anything that's not in the revocable living trust when I die, send into the revocable living trust. But guess what? That means you have to go through the probate process to accomplish that goal via your will. So it is a multi-step process, but that's why we call it planning and not reaction. The planning does have to be a thorough planning, but with regard to the tax savings, with regard to the probate legal cost savings, in a certain respect, you're looking at pennies on the dollar to plan ahead rather than confront the issues that you have to confront when, heaven forbid, someone has passed. But so many things are like that, right? If there's a terrible disease out there and you can get an inoculation that will ward off the disease. Yeah, it seems you have to go to the doctor's office, you have to pay for the shot. It might hurt a bit, but under a cost-benefit analysis, it's certainly much better than getting that actual disease and having to go through the issues that it might confront.
Cool. Brian, I was going to ask you, because you get the chance to sit before these families who are making this really important decision, and we sit on our side of the table, or maybe we have a meeting first with somebody and we end up bringing them to someone like you, Brian. And I think you mentioned it earlier, but the trigger points. So anyone listening to this show, if you get married, if you have children, if you buy a house, these should be like light bulb moments where what this estate planning thing is a very selfless thing, right? It doesn't actually benefit me because I'm dead in this scenario, right? It benefits my wife, my children, my grandchildren, if I'm so lucky to have them. I think that's maybe one of the reasons I've heard, at least, and I'm going to turn into a question in a second here for you, Brian, but why most people, or many people, don't want to do this because it seems daunting, overwhelming. And then maybe they're like, I'd rather be on social media, or I'd rather like buy a car, or I'd rather do something else with my time and money, where this is so important. Why, Brian, do you think people don't do this really important thing?
It's because the topic is rather distasteful, right? And the topic of the conversation is incapacity, physical incapacity, or death. Not exactly the topics that people would prefer to engage in if they had something else to do with their day. But what I say with regard to clients and who might need our services, I jokingly say, and I said this to my colleagues when we had Dentons partner meetings, is that who can use your services, Brian? Well, anyone who might possibly in the future die. Well, obviously that's everybody. And there are a lot of good trusted estates attorneys out there. But something's going to happen to all of us someday. Hopefully no time soon for everyone listening and for you, Jason, and you, Alex, but someday something's going to happen. Wouldn't you rather that your family, the people closest to you, can have a plan in place that would allow things in relative terms to go as seamlessly as possible? Absolutely.
Yeah, how could you say no to that, right? I mean, that's crazy. Jason and I, we have the luxury or the privilege benefit of having children that are healthy and they play sports, and we're spending all this time helping them raising the children, right? Being good husbands to our wives, these kinds of things. Like, of course, the answer would be, of course, I want to take care of my family. Like, okay, what do I need to do? What do I need to sign? Mm-hmm. If it costs $2,000 or $3,000 or $4,000 or $5,000, it seems worth it, right?
Yeah, and with regard, when you want to have health insurance for your children, heaven forbid they get hurt at a sporting event or what have you, yeah, you have to pay for it, but under a cost-benefit analysis, it's certainly worth doing to ensure that your child would be taken care of if they get hurt, if they get sick. When you think of the estate planning process, in essence, it's like family wealth insurance, for lack of a better term, where you're ensuring that your family will be taken care of, and there'll be a process that they don't have to spend tons of money and tons of time in a period of bereavement handling. In addition, if clients are wealthy enough, and I know we'll get to estate taxes or transfer tax system, the proper planning can literally save millions and millions of dollars in estate taxes, because what most clients don't realize while they're building their businesses, raising their families, etc., depending on their wealth and depending upon the tax laws that are in place at any particular time, they have a silent partner. That silent partner is the IRS. And the extent that that silent partner will benefit is potentially speaking up to 40%, 40, not 14. Some of my clients have selective hearing. They want to hear 14, the number after 13. No, it's not 14. It's 40% of an estate tax. And those tax rates may be going up to a minimum of 50%, up to a potential federal rate of 65%. And in the state of California, the folks in Sacramento have also realized that, hey, wait a minute, there's something we haven't taxed at the state level yet, because California does not have a state level estate tax, an inheritance tax. Well, they're talking about it in California. So when you think of the collective burden of your silent part of the IRS, potentially speaking, taking 40% over a certain exempt amount of the family wealth, well, California is beginning to have those discussions as to how much they should take as well.
Yeah, that's just crazy, right? When you think about that we pay tax on our income, we pay property tax on our house, we pay sales tax on the goods we buy. And now when we die, if we've done well and we've worked hard and saved and been prudent, we're now going to pay tax because we died.
Mm-hmm. Yeah.
Okay.
And Californians can pay, if there are trusts established out of state, there are certain what are called throwback taxes that California has. It has amongst the highest, and I say this from New York, where I'm sitting, but we have offices throughout the country in high tax states like Massachusetts, Connecticut, California, Illinois, New York, New Jersey, the usual suspect states. The government in California has a very, very high, amongst the highest state income tax rates in the country.
Yeah. What other states have actually started an estate tax at the state level, not the federal level?
The state of Washington is one of the new entrants. So when we look to the West Coast, the state of Washington now has a state level estate tax.
Wow.
The exemption is a little over a few $1 million. So it's a relatively low exemption versus the current federal exemption of over $13 million. But Massachusetts, New Jersey used to hold the title of worst state estate tax several years ago. The state of New Jersey used to have an estate tax exemption for the state of New Jersey estate tax of $675,000.
Wow.
Can you imagine everything above $675,000 in an expensive state like New Jersey, which is cornered by New York in the north and Philadelphia in the south, having a $675,000 exemption? Everything above that is subject to the state of New Jersey estate tax. Well, they did get rid of that, and they correspondingly raised gas taxes for some reason. I don't know what the connection was, but at the same time they got rid of the state of New Jersey, got rid of the state estate tax, it raised the gas taxes. But the state of Massachusetts currently has a $2 million exemption. And they consider that very generous because they just increased it from a $1 million exemption from the state estate tax. And what most people don't realize, for example, even if they're out of state in Massachusetts, just use Massachusetts as an example, if you own, let's say, a place on Cape Cod, or you own a place on Martha's Vineyard, and you live out of state, most people say, oh, well, I'm not a Massachusetts resident. I don't have to worry about that. Yes, you do. Because Massachusetts will tax, for state estate tax purposes, your real estate that you own outright in Massachusetts upon your passing, and it'll be because it's there in Massachusetts. So Massachusetts has a state estate tax, New York has a state estate tax, and Connecticut has not only a state estate tax, but Connecticut has a state gift tax. The state of Connecticut monitors what you gift. In addition, with regard to also Illinois, I think has a $4 million exemption at their state estate tax level. But for example, New York and Connecticut have what we call a cliff tax. What does that mean? I'll give you an example of New York. No gift tax in New York, just an estate tax. The exemption is about $7 million. I'm rounding up. So if you are just a bit under the exemption, let's say you have $6.5 million, and you die in New York, you're leaving it to your kids, no New York state estate tax. But let's say you're just a bit over that, about approximately $7 million exemption amount in New York. New York says, you have enough money, we're taking your exemption away, and we're going to subject all of your assets, let's say $8 million. You don't get a $7 million deduction. All of your assets from $1 through $8 million get subject to the New York state estate tax, and you take your exemption away because you're too rich and you shouldn't have it. So in essence, You're going over the cliff if you're just a bit above the exemption. That's why we call it cliff tax.
California, it's back to California real quick, because I was looking at some questions that were asked of my team yesterday when I was preparing for the show. Like, hey, what are clients talking about right now? What are they thinking about? And I think we covered most of them with the first part of the show already, with the reasons why you get an estate plan, how you do that, why you should, okay. As you start to get into California rules, because a lot of our clients here are California based, there's no state estate tax. So they charge us enough on everything else. We're okay there. But the federal,
for the time being, for the time chatting about it on Sacramento.
The TCJA, the TECJA, right? The Tax Cut and Jobs Act is sunsetting at the end of next year. So that's probably why there's a lot of people that are like buzzing around like, oh my gosh, we got to do estate planning now, because whether it's Biden or whether it's Trump, there's a chance everything gets worse tax wise if you die, right?
Yep.
Okay.
Correct.
So in California, if you're wealthy enough, or if you're lucky enough, fortunate enough, successful enough to have this problem, let's put a number on it. Is it 10 million net worth? Is it 14 million net worth? At what point do you need to start getting really, really into this right now for complex estate planning?
Sure. So everyone needs the foundational estate planning documents. And again, very quickly, that includes the last will and testament, but also the joint revocable living trust in California, durable power of attorney, healthcare proxy. You talk about that a bit later with regard to foundational documents. But with regard to tax planning, that's really coming to the fore, because when the tax act that you just mentioned, what many people call the Trump tax cuts, were passed at the end of 2017, they automatically were built to sunset at the end of 2025, many of the tax cuts. And those include the big exemption from the federal estate tax. That was done because of what they call the Byrd rule in the Senate. With regard to tax cuts, you can only project out for a period of time. And then those tax cuts, this happened under President Bush as well, when his tax cuts were going to expire under the Obama administration. Some were extended, some were not. So we're in the same type of situation by the end of 2025. with regard to sunsetting tax cuts. Among the tax cuts that will be sunsetting is a very generous $13,610,000 federal exemption from the gift and the estate tax per transferor. And that exemption officially can go down to $5.5 million, the old exemption, plus an inflationary factor that would get attached to it. So in the $6 million-ish range. But potentially speaking, this exemption from the federal estate tax can go down by half. Now, President Biden has a plan that only wasn't passed because of Senator Manchin, when the Senate was split 50-50, and Senator Manchin wouldn't vote for it, whereby today, if Senator Manchin did vote for it, we would have a $3.5 million exemption from the federal estate tax, and the minimum rate above $3.5 million would be 50%. That's 50.
So 3.5, that's per person. So if you're a married couple, if you're worth 7 or more, planning is mandatory if you care about the next generation.
Yeah.
And not,
so we have the election in November. It kind of depends on who wins. So for example, if the Democrats, for example, run the table and they're able to pass President Biden's tax plan, as he might wish for them to pass it, that means a $3.5 million exemption with a minimum state tax rate above that of 50%. If we end up with divided government again, a lot of people think that's what's going to happen. Some people say, well, looks like the Democrats can take back the House. Looks like the Republicans can take back the Senate. Then from a tax policy point of view, it may not matter who wins the presidency, because there may be one party who may not want to pass the extension of the tax cuts. So that's when we have the sunsetting of the big $13,610,000 exemption down to more in the $6 million range. And hypothetically speaking, if you took a $26 million couple, just use a nice round thing, let's call the $13,610,000 exemption $13 million exemption. Right now, heaven forbid if they passed away, or if they did the appropriate planning, they could shield the $26 million because they have these big exemptions where they could do that. If the exemption drops down, hypothetically speaking, to $5.5 million, think of it, heaven forbid they both pass away after that. Take $26 million, subtract out for two spouses, two $5.5 million exemptions. 26 minus the 11 gets you down to $15 million, subject to a 40% estate tax. And that's a $6 million tax that otherwise could have been avoided. So it's a big difference with regard to clients who have been very successful, or they've owned real estate assets that have appreciated over time, or they've had wonderful advisors like the two of you who've made them richer.
Yeah.
So that's where we get into the conversation about a couple specific strategies. One that you've taught me a lot about, Brian, which is SLATs, Spousal Lifetime Access Trust. So how can you deploy those to make a difference? Would you walk through that at a high level for us, just as a little teaser? And then we want to let everybody know we're about 23 minutes into the podcast. We like to keep these around 30 or so, that you are welcome to give us a call, because this is a lot of information. It's heavy and it's extremely personalized. Every individual and every family has a different objective and goal here, and how you develop this estate plan is totally personalized. There is no one box fits all. 877-707-8889, 877-707-8889 is the best way to get a hold of us, or you can just shoot an email to jason@financialdetox.com, jason@financialdetox.com. We will likely introduce you to somebody like Brian, and Brian specifically, because he is the person, and his firm at Dentons are the ones who will actually draft documents and get into the nitty-gritty detail of this. So let's talk for a second, Brian, about the SLATs, Spousal Lifetime Access Trust. This concept is really cool. And I think regardless of what happens with the estate tax, this isn't wasted planning per se. So why don't you walk us through how that works at a high level, and then we'll maybe talk just for a minute about LLCs and discounting, maybe real estate and that one other strategy, because those seem to be kind of two down the middle of the fairway type strategies. And then we'll close on that. And I would love to hear from you on that.
Sure. So with regard to SLATs, as you just mentioned, Jason, Spousal Lifetime Access Trust. My area of law loves acronyms, so we have fun. But with regard to SLATs,
Exactly.
This is the one that's the topic of the moment. So let's say, going back to that hypothetical $26 million couple, right? And say, hey, you have a wonderful opportunity, Mr. and Mrs. Jones. You can each give away $13 million worth of assets, pay no gift or estate taxes, and those assets can be transferred to trusts and protected from all future estate taxes, generation to generation to generation, if properly structured. And the couple might say, well, that's lovely, Brian, but so if we give away our $26 million in a trust for our kids, we have nothing and our kids are rich. I like the idea of the tax savings, but boy, we have a long retirement and we have a lot of things we'd like to do and a lot of places we'd like to go, and we need money to do that. I say, hold on. When we gift away assets, you do not have to gift them immediately down to the kids. The kids will just be delayed, but they won't be denied if you look to gift into trusts for a spouse, spousal lifetime access trust. So for example, the way that it would work is husband, for example, is permitted to make a transfer of $13 million worth of assets up to his exemption, $13,610,000, into a trust for the benefit of his wife initially. It doesn't have to go immediately to the kids. The kids can be a beneficiary of this SLAT, Spousal Lifetime Access Trust, but the husband can make a gift using his exemption into a SLAT that's initially for the benefit of the wife, and then ultimately down the line will cascade downward free of estate taxes, because a trust, when properly crafted, doesn't die, a human does. So a properly crafted SLAT will allow the assets to pass downward through the generations, because no human being ends up owning those assets. They're held in trust for initially spouse, who could be a primary trustee of the SLAT. They have a co-trustee as well. And ultimately the assets will pass free of estate taxes after the wife, in my example, has utilized the assets in the SLAT to the extent that she felt the need to. And the assets, again, pass estate tax free, plus all the growth passes estate tax free down to future generations.
Awesome. And then the wife in turn does the same thing, gifts the assets to her husband. And now those assets pass down as well. And this is where you wrap maybe a dynasty trust around it, so that this kind of goes on in perpetuity, as you said, maybe even through not only the immediate beneficiaries, but then the kids, the grandkids, those next beneficiaries. So this is a way utilizing the current high estate tax exemptions, which is possible, not guaranteed, but possible to come down significantly, to utilize that and lock that big exemption in so you don't pay state tax. If you didn't do that and you die in the wrong year, 2025 or 6, let's say, or 26, and the estate tax exemption had sunsetted backwards, and you had a $25 million estate, and even if it sunsetted to 5, you would have 5 per spouse. So that's 10. If you had a $25 million estate, you're talking about a significant estate tax bill of at least $7 million.
Millions of dollars.
Yeah, millions of dollars, as opposed to spending some money on the front end. And like you say, Brian, I love it. We're doing planning instead of reacting to the events that could happen.
Well, and I've got the 26 million. I'm taking 13 million of my stuff and moving it into one of these SLATs. So let's say that stuff is real estate that I bought 30, 40, 50 years ago. And the basis is low, right? And there's a big gap between what I bought it for, the basis, and what it's worth.
Mm-hmm.
What are there any considerations that people need to think about in terms of, like, are there any consequences for the basis part? Is there some sort of trigger of gains, or is there some sort of property tax reassessment or anything like that?
Yeah, there's not a trigger of gains by a gift of an interest in real estate. However, with regard to what you're alluding to, Alex, is step up in basis of what you die owning. The nice thing about your typical SLAT is that it's also what we call a grantor trust. SLATs can be a lot of things wrapped into one thing. I use the silly example. I'm an attorney. I'm also the chairman of our trust of estates department. I'm also a licensed CPA. I'm all these things wrapped up into one little weird bag. But a SLAT can be a dynasty trust if you properly structure it. That means it could last literally forever, as long as there are assets passed downward. And it's a grantor trust. With regard to being a grantor trust, you're allowed to substitute assets. The grantor is allowed to substitute assets in and out of the trust without any tax ramifications at the federal gift tax level. So you can manage things over time to determine, hey, look, exemptions go up, exemptions go down. What am I going to die owning? And if you, let's say, or the husband in my example, and you transfer assets to the SLAT, maybe you substitute assets in and out. Let's say you built up cash outside of the SLAT and you're going to die with something. Well, put the cash into the SLAT, take low basis assets out in a tax-free substitution. And then when you pass owning the low basis asset, there's a step up in basis. So there's lots of ways that we can continue to monitor the situation to save a lot of not only estate tax, but income tax and capital gains tax for clients.
Gotcha.
Thank you. Thanks, Brian. Again, super heavy topics. I mean, when you start talking about spousal lifetime access to us, transferring assets and all this is why I think people don't do this, is because it seems overwhelming and complex. But that's why you hire professionals. I mean, a small analogy is I tried to hire on the low end, people to do construction at my house. And it was a disaster in every scenario until you go find the right person who knows how to do it and who's done it a bunch of times. then you pay more, but you get the right outcome, and it becomes very simple when you have the right people working for you. Same with investment management, same with portfolio construction and adding alternatives into your portfolio, estate planning, even tax planning, and so on. So Brian, you're so helpful. Just again, you can give us a call at 877-707-8889. That's 877-707-8889, or call or shoot an email to jason@financialdetox.com. The last thing just to hit on, because I understand this enough to probably make myself look really stupid, Brian, and get way over my skis. But the whole concept of being able to create an LLC, move assets into that LLC, family members or beneficiaries have some beneficial interest, but they don't have control. So therefore you get to discount the value. And that's a way to also move more money within the rules that are allowed without paying estate tax. Can you hit that? Is that reasonable to hit quickly?
Yes. We can go over a little bit. Don't worry.
Yeah. We'll go. It's okay if we go over. We have no time limit.
We make up our own rules, right? No.
Yeah, exactly.
Sounds great. It was a way with taxes. But
right.
Regarding gift transfers, right? You can only transfer so much during your life before you get hit with a gift tax. And you can only die with so much before you get hit with an estate tax. So in essence, to make gifting efficient, what if you could crunch down the legitimate value of an asset so that it takes up less of your exemption to transfer, right? That's leverage.
Yeah.
That means that there's more exemption available so you can transfer more assets free of gift and estate taxes. So I'll just give a quick example. So let's say, Jason, I want to transfer to you a $3 million piece of land.
I like it.
I just want to give it to you. And you
this
say,
is great. Let's do that.
All right. So if and let's say everyone agreed that the land was $3 million. The IRS agreed, the appraisers agreed, you and I agreed, $3 million, everyone agrees. If I make the gift to you, I've used up $3 million in my exemption. Alternatively, what if I put the same land in an LLC and I gift 50%, Jason, of the LLC to you and 50% of the LLC to your wife? It's getting in essence where I want it to go. Because of the ability to discount the value of a partial interest, and these are called lack of marketability discounts and non-majority interest discounts, you can crunch down the value typically by at least 1/3 because you value something as to what someone in the open market would pay for that independent gift. What is someone in the open market choosing going to pay for half of an LLC that owns land? They might say, I don't control it. I don't have the majority interest in the LLC. I'll pay something for it because there's inherent value, but I want a discount. So the long story short, Jason, is that instead of me giving you a $3 million piece of land with no planning around it and using up $3 million of my exemption, with the 1/3 discount, I can give you half of the LLC that owns the land and half to your wife, with each of those LLC interests valued at only $1 million each, taking a $3 million asset and crunching it down legitimately as recognized by the IRS to a $2 million value for gift tax transfer purposes.
Yeah, that could be super powerful in a lot of different ways, especially with real estate, right? And other holdings that are, I guess, does that work? Doesn't work for publicly traded securities or liquid securities, would it?
No, not when the LLC is let's say 100% securities. But however, if that LLC owned primarily land and there were some securities, you may be able to get the discount on the securities as well.
Awesome. Really cool topics. What do you think our listeners should do? They reach out to us at Financial Detox. They set an initial discovery meeting, give you the lay of the land. How does that work? And then so that they can get an idea of this first step. And so they see it's not terribly complex, even though the topic is complex. But when you hire the right people, that's our specialty, is right, making something that's very complex and challenging super easy and digestible.
Yeah. So with regard to any client, having the right team in place is essential. Having you, Jason, you, Alex, in as the financial advisory folks doing some excellent due diligence and helping move the clients forward with a plan. Even though I'm a licensed CPA, I don't take the seat at the table as the CPA. I take the seat at the table as the trust estates attorney who just happens to be a CPA. So I know some additional tax law that maybe some other trust estates attorneys don't know. But then you bring in the CPA as well. And there's your trifecta team that can help properly plan for the future. But the wonderful thing that Jason, you and Alex do at your firm is to do that due diligence, to recognize a client's profile, because you have some idea what the net worth is. I'm in my law offices, I just wouldn't know because I'm not frontline. You're frontline folks who can ensure that, hey, look, you may have an issue here. If you have no estate planning documents, you have no plan, but also you have some tax issues that need to be addressed, especially with changing tax laws. with regards to this decreasing exemption, it's a use it or lose it proposition. If you don't use the exemption while you have it, you lose it and it goes away in the future. So frontline clients and potential new clients, speaking to the two of you, you can do some due diligence to be able to bring in the appropriate team.
So Brian, I like what you said about that, because that's exactly what happens with us, right? We get to know a client very, very well, and we build in these financial, Jason's on it because he knows exactly where I'm going with this, but we build an entire financial plan. We actually know their net worth better than anybody, better than them even, because we're getting a precise, accurate depiction of their entire worth so that we can help them, give them comprehensive advice. And I think the one thing you said earlier, even Brian, really touches on something that I think about when I try to introduce this subject to people. Let's use the $7 million number, by the way, just because that's like the worst case scenario right now, given the information we have in 2026. If you're worth 7 or more in California, that's when you really
5 or
need to
more.
start. Okay, 5 or more.
Individual.
5 or more, we've got a problem, most likely. And so I think the way to distastefully use the word distasteful, it's a perfect way to think about like why I don't want to think about this. It's distasteful. I'm either dead or I'm incapacitated, right? But the before you even do any of the planning and the documents and all that stuff, like I think if I'm in that seat, I would want to think about like, okay, I worked really hard my whole life to build what I have. I don't want my next generation or the generation after to blow it, and that's statistically likely to happen, right? And so instead of focusing so much on numbers and math and distasteful things, I want to think about what values I want to transfer to the next generation. Like what matters to me, what I think my kids should matter to them, and guide that conversation. So we talk about family governance and family charters, and that's the start of the conversation for how we do it, Brian. And then that way, by the time it gets to you, you don't have to convince them of anything. You're just trying to explain the concepts in a way where they understand and they sign, right?
Yeah. And also, corresponding, there's something else that's distasteful. My wife and I have 3 kids. Hypothetically speaking, if the government took away 40% of my wealth and there's 60% left, each of the kids get 20%. That means the government got twice as much as each one of my kids. Not exactly what I was looking for when I was working hard all these years.
Not cool.
So I just use those, broad numbers, but that's kind of distasteful too.
Yeah, it's criminal actually, but we can save that for another show. The actual stealing of assets. But this has been powerful. I knew it would be, Brian, having you on here. You're such a great resource at our financial advisory firm, our RIA IDA Wealth. This is what we do: is we take care of, like Alex said, the comprehensive, holistic financial plan. Bring in the people that we need to from a specialty standpoint, like Brian and his team at Dentons. These guys are some of the best in the world at what they do. Brian, we're so grateful to have you and your relationship and your time and intellectual capital that you've just poured out on this show, Financial Detox, to help our listeners avoid toxic advice and manage their wealth for maximum impact. Thank you for doing that. And thank you for being here. We know how to get you in touch with Brian very easily. He's unbelievably responsive. So you just send an email to jason@financialdetox.com. We'll get you connected and we can help facilitate that conversation. So when it gets to Brian, he's ready to rock and roll and do his thing. I don't have any other closing comments. You guys feel like we covered it? We're looking good?
Awesome. Thanks very much for the opportunity, Jason and Alex. I appreciate it.
Pleasure to have you. Thank you again. And this is Financial Detox. We're signing out for this week, this show, and we will catch you on the next one, 877-707-8889. I'm Jason Labrum with Alex Klingensmith and Brian Raftery. Thank you. Bye-bye.